to handle it at his or her own space, her own pace. I mean, after a matter is assigned by the National Agency for Legal Aid, the legal practitioner assigned the matter is expected to pursue the case diligently. In addition, the legal practitioner too is expected to provide information to NALA as to how the case is proceeding in court. Okay. So you have to give information to NALA on how far the case is going. And of course, if a case is assigned to you, like I said, just emphasizing, we would expect such a lawyer to have the case handled with diligence. I mean, I know we have very professional lawyers in this country, but then just to emphasize, that is what the law says. I know at the end of the day, if a lawyer gets a case, I mean, the lawyer would be expected, even though it's a case from NALA, because we know NALA cannot really afford, you know, the kind of money rich people would pay private practitioners. But at the end of the day, irrespective of how much is given, a lawyer who decides to take up a case from NALA is always expected to handle the case with diligence and, of course, the required skill expected from a legal practitioner of his standing.
Now, what happens if the person being represented is not satisfied with the legal representation and taking cognizance of the fact that he or she was just being aided by NALA, the National Agency for Legal Aid?
Yeah, if an accused or in a criminal matter, yes, if you're not happy with the kind of legal representation you have, you're allowed under the Act to change. You can apply to NALA to change. But then it's not just about you walking away. You have to follow the provisions of Section 33. Yeah.
Subsection. The reason why I asked that, you know, as the saying goes, you know, a beggar has no choice. Something like that.
Well, I would not want to accept that idea. A beggar has no choice.
Okay.
Yeah. The fact that, you know, you have been provided with lawyer by legal aid does not mean that you don't have a choice as to the performance of that particular lawyer. Okay. If you are not satisfied with that lawyer, you should inform the court, and the court invariably, you know, will also inform the legal aid
office.
Yeah. And then we will look at the issues or the circumstances surrounding your dissatisfaction. Okay. If there is, you know, merit in what you are complaining about, of course, the legal aid will also consult the judge or the magistrate. If what you have said, you know, is proven to be true, then legal aid will have to change that lawyer.
Exactly. So,
just to emphasize, on the other side of the coin, can the legal the practitioner also?
Yes, if, for example, a lawyer has good reasons, maybe not to represent someone, you know, this is really a very, very small society. Of course, the lawyer can do so. But then, like I said, going back to someone provided with legal aid saying he or she is not satisfied with the lawyer, we're not expecting such a person on his own to walk away from the lawyer. There is a process you follow, which we have provided for in Section 33, as in subsection 4. I mean, you would have to inform the Executive Secretary of NALA, that's the National Agency for Legal Aid, and you would also have to await the approval of the Executive Secretary or his representative. After that is done, you also have to bear in mind, I mean, just because you're withdrawing, it doesn't mean you are allowed to impose additional expenses on government. You know, maybe if, for example, 5,000 was given to the lawyer representing you, you cannot withdraw expecting the agency to pay 10,000 to another lawyer, provided, of course, the withdrawal wouldn't lead to the agency incurring additional expenses. Yes, that is in the case of someone not satisfied by his lawyer. A lawyer, too, like I said, can reject or refuse a brief, but then we would expect the lawyer to, everybody, you know, has a defense. My lords made the point clear at the very beginning, as in the right to counsel is a constitutional right. So if you approach a lawyer, maybe the lawyer is really not keen on accepting your case, but then we would expect the lawyer to have good reasons why he or she is really not ready to either take up your case or to maybe hand the case over back to the National Agency for Legal Aid. The lawyer can do so, but then here too, the lawyer must comply with the procedure set out in Section 35, subsections 4 to 6, as in we would expect the lawyer to you know, write to the Executive Secretary, who would at least make sure all other things are considered before a decision is made on the matter. We don't just expect you to say, this client has been giving me problems. He's been calling me left, right, and center. I'm tired of this case. Nala, this is it. There are processes, and the law is really very clear on what those processes are. Yes.
And each of the matters.
And again, we must take into consideration the fact that lawyers are also guided by ethics.
Ethics, yeah, okay, that's why we're coming.
And there's another act also covering the conduct of lawyers. And the lawyer, in as much as he owes a duty to his client, his paramount duty is owed to the court. So when an accused person or a client says, I'm not satisfied with my lawyer, you better be sure what you are complaining of.
Force.
The judge or the court, shall I say, is aware and knows. Because just as Mr. Sow said, you cannot just get up and walk away from a lawyer. Or you cannot say, well, maybe this particular lawyer does not speak too well, or this particular lawyer does not speak as secretary as I want, or this particular lawyer is ugly and I don't want him and so on. No, it doesn't fall like that. The legal aid will look at your case and assign the case to who they consider is most efficient to handle that case.
Exactly.
And once that is done, you better be sure that you open up to that lawyer. Because lawyers also are not angels.
Magicians or angels.
When you have a bad case, see, the lawyer knows how to plan his case. So it is you who will have to tell the lawyer what is involved in your case. If you have done what you are alleged to have committed, you better open up to him and tell him. He is the one that knows how to defend his case. But when you hide the truth from him and he faces surprises, if he cannot handle them, then too bad for
catastrophe comes in.
My lord is speaking as a private practitioner now.
But it's fair at least for the viewers out there, at least watching, because that's why this program is important.
Time and again we hear people say, that particular lawyer is no good.
It's not good.
Or that particular lawyer is very, very good, quite excellent.
Excellent.
But that would depend on the information that lawyer has gathered.
Your briefings.
Like Lord Denon once said, the law is an ass. Sometimes, cases are won on technicality. You may have a very, very good case. But when you go into that box, you mess it up. You cannot expect the lawyer to repair the damage.
And the magistrate or the judge will be just listening to the facts being adduced as the proceedings unfold.
And lawyers will not just walk away from a case. I do not know of any instance. In fact, there have been occasions where when I was in private practice, a particular judge would say, Mr. X, could you please handle this matter on a pro bono?
Meaning what? Pro bono meaning?
Do it free of charge.
Okay.
And readily, people do consent. I know a particular lawyer, who is commonly known for taking pro bono cases at all times, and that is Mrs. Nene Cham, Chongan. And I really congratulate her for that. Because he's done so many of those cases. I think he's a champion in that area. She's a champion in that area. Of course, that does not mean that the other lawyers do not.
Do not, they do.
Let me just go back to
okay,
it's rejecting, yes.
Back to
yes, so I'm just trying to, I just want to make sure at least this is made very clear. Yes, a private legal practitioner can decide to reject the case with good reason, like I said earlier on. But then such a lawyer has 14 days within which he or she is expected to notify, of course, the National Legal Aid Agency that he or she is rejecting the brief. The time is specific. So which means if a case is assigned to you, you have 14 days to decide on whether you're going to take up the case or not. Because we have an additional subsection saying if you do not notify within the 14 days stipulated, it is assumed you're taking up the matter. So yes, you can reject, as in you can decline a brief, but you have to notify the agency within 14 days. I think 14 days is quite a reasonable period. If you are quiet after the 14 days, His Worship, Mr. Thomas and others would say, we've not heard from the lawyers. Probably he's decided to take up the case. So that way you wouldn't really be in a position to blame them if they keep expecting periodic updates from you.
Now, I'll just come to Justice Jabata here. I think you're wearing 3 caps, if I due respect. Now, you're a judge of the High Court, chairperson or chairman of the National Legal Aid Board, and being a former private practitioner. Now, in your own opinion, if you are to gauge or evaluate the impact or the effectiveness of this legal aid services being provided, how effective it is compared to the others who are on the other sideline who goes on their own?
I don't want to be seen to be biased.
Okay.
And so based on that, I am giving my honest and frank opinion.
Good.